Just a few words about me. I have worked a lot on the issue of sexual violence. I conducted the first prevalence survey on sexual violence against adolescents in my country, which was later replicated in all countries of Western Balkans. I'm a researcher and consultant, and I work for UN agencies, European Parliament, Council of Europe, European Commission, you name it. First of all, I want to say that I welcome the initiative of Rape Crisis Network because in our baseline evaluation reports, we as GREVIO very often recommend that the data categories in use in data collection systems should be harmonized across the various sectors. I cannot comment on specific definitions that are suggested in this initiative, but I appreciate the effort to establish common definitions. I heard that Ireland is currently developing a new national action plan, so I would suggest you to consider including this initiative into the national action plan. Going back to explanation of the Article 11 of the Convention, which deals with data collection and research, my first point is that when explaining this article, it is helpful to start with its purpose, which is evidence-based policy making. Data collection and research are tools that should be used by state parties to identify gaps in the implementation of laws and policies, to measure countries' progress in meeting the obligations specified in the Convention, and guide policy making to create proposals for improving the legislation, its application, and to revise the policies. To simplify a little, if the provisions contained in Article 11 are not implemented properly, it becomes difficult to assess whether the Convention as a whole is implemented properly, and that is why data collection and research are so important. The second point I want to make, requirements related to data collection should be viewed within a wider framework of the Convention, and all efforts in this regard should be undertaken taking into account Articles 6 and 7, and let me remind you of these articles. The Convention reaffirms gendered understanding of violence against women, and a clear gender dimension overlaps its various provisions. Article 6 requires parties to ensure a gender perspective is applied not only when designing measures, but also when evaluating their impact. Therefore, a gender impact assessment should be carried out in the planning stage of any measure. Further, in the evaluation stage, it should be determined whether there is a gender differential in the impact of the provisions. It is self-evident that a possible gender differential in the impact cannot be determined without sex disaggregated data. Secondly, Article 7 implies that parties are required to establish a comprehensive policy response along all four pillars of the Convention: prevention, protection, prosecution, and integrated policies, which means to create comprehensive and coordinated policies sustained by the necessary institutional, financial, and organizational structures. So when you are developing a new national action plan now, I would like to inspire you to think, have you developed equally strong measures across pillars of the Convention? Are measures related to protection complementary or contradictory to measures related to prosecution? I'm saying this because I found such examples in many countries that I analyzed so far. I would like to go back to this issue in a discussion, but just let me ask one question on this point. As far as I know, Ireland is doing very well when it comes to specialist service provision to sexual abuse victims. The question is, did you meet the requirement related to number of services, which is one sexual violence referral center or rape crisis center per 200,000 inhabitants? So far, we found only one country, that's Denmark, which met this recommended standard. In the process of developing the National Action Plan, and also because soon you will be evaluated by GREVIO, I would like you to suggest to you to use one useful recent source. That's midterm horizontal review of GREVIO baseline evaluation reports. You can find examples of good and bad practice in data collection there, and I will mention a few in this presentation. Finally, I would like to stress that Article 11 should be read in conjunction with Article 10, which specifies that one of the roles of the national coordinating body is to coordinate data collection, analysis, and dissemination of data. So my question is this already included as one of the tasks of the national coordinating body in Ireland? Going back to explanation of the requirements of Article 11, first of all, I should explain that paragraph 1A includes an obligation to systematically, at regular intervals, collect statistical data on all forms of violence covered by the Convention, and that includes administrative data compiled by healthcare, social welfare services, law enforcement, specialist services, as well as judicial data recorded by prosecutors and courts. Here I want to add that in some GREVIO reports, we clarified that this requirement to collect data applies to those women and women's NGOs that are publicly funded. In order to build up comprehensive data collection systems that can serve a wider purpose of designing and evaluating policies, as I explained, it's crucial to set up comparable data categories, and that's why I welcome this initiative. Data collection system in different state agencies should go beyond internal recording purposes, and data categories in use should be harmonized across the various sectors, especially law enforcement, prosecutors, and judiciary. GREVIO also often emphasizes that it should be possible to track cases from reporting to indictment and beyond across the various stages in the criminal justice chain in relation to all criminal offenses required by the Convention, and to identify outcome of cases. Further, in line with Article 11, all recorded data should be disaggregated by sex and age of both the victim and the perpetrator, the relationship between them, type of violence, and geographical location, as well as other factors deemed relevant, such as disability. Article 11, paragraph 1b requires to conduct research on all forms of violence covered by the Convention, including research on the root causes and consequences of violence, incidents, conviction rates, as well as the efficiency of measures taken to implement the Convention. There are huge problems in this area. Paragraph 2 further specifies that parties should conduct population-based surveys on prevalence of all forms of violence covered by the Convention in regular intervals, so the changes over time can be examined. Paragraph 3 of this article includes the obligation to provide GREVIO with the information provided by different data collection systems in order to stimulate international cooperation and enable international benchmarking. Ireland will be involved in this process relatively soon. Paragraph 4 requires that the information collected should be available to public, and while doing so, parties should pay attention to the privacy rights of persons affected. This means that the data for public use should be anonymized, that individuals should not be identifiable. We as GREVIO repeatedly recommended that parties should ensure that when they are analyzing or storing personal data, they should comply with the standards included in another Council of Europe Convention, which is called Council of Europe Convention for the Protection of Individuals with regard to automatic processing of personal data. Let me give you a few examples of this provision. In report on Italy, we found problems related to protection of personal data of the victims. In certain regions of Italy, the authorities developed criteria for local funding of specialist services. In Italy, they're called anti-violence centers. And the regional authorities asked the centers to provide victims' personal data, their fiscal codes, as a condition to continue funding. The explanation was that the authorities want to monitor incidents of violence against women and to analyze activities of these centers. We strongly criticize this practice, and we often, and including in this report on Italy, we recommended to the authorities to comply with standards of personal data protection and to respect working methods of specialist services, which grant victims privacy and confidential disclosing of their experiences. We also clarified specific standards in this area, which are: unauthorized access to personal data should not be possible. All participating agencies should follow clearly defined protocols regulating procedures for data sharing. Full anonymity should be granted to persons whose personal data have been registered, including the requirement that such data should not be shared without their informed consent, and individuals should not be identifiable through data that are available to public. Similar considerations are provided in our report on Turkey. In Serbia, we strongly criticize the practice of the National Helpline, which records the calls digitally. And the authorities explained that these recordings are made only for the case that the victim wants to initiate legal action, and that calls will be released only to the court on the special request of the court. But of course, we criticize that practice for the reasons that I just explained. Let me now give you a few promising practice examples in the area of data collection. We praised Portuguese authorities for introducing the obligation to collate data from law enforcement and judiciary so as to reconstruct the entire criminal proceedings chain from the filing of the report or the complaint to the law enforcement to the delivery of the judgment by the court. This is crucial. In Spain, we commended the authorities for their data collection on intimate partner violence against women. As an example, National Police Statistics Service collects data which is disaggregated by sex, age, type of crime, relationship with a victim, location, province, and other significant details. In Sweden, we took a positive note of collection of data on FGM, female genital mutilation, by healthcare services, including codes indicating pregnancy complicated by FGM. With respect to evidence-based policy making through supporting research, we commended Sweden for their leading role in policy making. We especially were impressed by the fact that they have a research center which is dedicated exclusively to the study of men's violence against women. Similar considerations were provided in our reports on Spain, France, and Belgium with respect to evidence-based policy making. Now going to explain a few typical shortcomings related to data collection that are probably relevant to your country as well. I'm sorry to say, but parties that fully comply with the requirement to disaggregate data by all categories required by the Article 11 are rare. Weaknesses are present even in countries that are well known for their achievements in gender statistics. On this point, I have to say that I read a survey conducted by Rape Crisis Network, and I was surprised by the fact that some entities or organizations do not disaggregate data by sex of both the victim and the perpetrator and their relationship. To give you examples, in many parties, including Belgium, Denmark, Malta, Monaco, Montenegro, the Netherlands, we identified that sex disaggregated data on victims or perpetrators is not collected by criminal justice sector. In particular, there is a problem with recording the victim-perpetrator relationship, and this information is absent in administrative or judicial data in many countries, including Albania, Belgium, Denmark, Finland, Italy, with some exceptions, Malta, Montenegro, the Netherlands, Poland, France, with some exceptions, or the categories used by law enforcement or judiciary are too broad to capture the actual nature of the relationship. This is the case in Sweden, Finland, and Austria. As an example, categories used in Sweden are acquainted with the victim, not acquainted with the victim, together with categories indoors, outdoors. This is helpful to some extent, but it's not specific enough. So we often recommend it to many parties to develop data categories on the victim-offender relationship for all forms of violence against women that would allow the nature of the relationship to be more specifically documented. This is something which is addressed in the Rape Crisis Network document. In Andorra, Denmark, Italy, and Malta, we noted a lack of data on child victims and witnesses. In particular, there is a problem whether courts, when they are deciding on custody and visitation, take into account histories of domestic violence. I don't know if this is covered in your practice of data collection or not. If not, I would suggest to include this issue. In the majority of the parties, there is no harmonization of categories used by institutions in criminal justice sector, law enforcement, prosecution, and courts, and it is not possible to track cases from reporting to final judgment by the court. So we, as GREVIO, repeatedly stress that an important element of harmonization is the use of common definitions and units of measurement. We also found that data collection on different measures that fall under protection is underdeveloped. As an example, data on access of victims to healthcare is limited to domestic violence or is absent in many parties. In some parties, including Andorra, Malta, Portugal, Serbia, and Spain, administrative data collection is limited to domestic violence, and other forms of violence are less covered. My final point example is related to attrition, but I would like to leave it for a discussion. I would like to go back to my previous point on inconsistency of measures across different pillars of the convention, and how analysis of attrition should be included in national action plans, but we can leave it for a discussion which I'm hoping that we will have later.